Welcome back to Generative AI and the Delivery of Legal Services. Today we're going to talk about ethical and regulatory implications of AI in law. First, duty of competence and tech competence, then confidentiality and communications, followed by supervision delegation and UPL, and then finally, minimizing bias and its sources. First, let's take an overview of ethics. Now, this is from the ABA Model Rules. 1.1 talks about competency, 1.6, confidentiality, and 2.1 talks about an attorney maintaining their independent professional judgment. And so each of these is going to play into how generative AI affects the practice of law, and we'll find out more detail about how they impact it as we go. So first, the duty of competence. We'd be remiss, of course, if we didn't mention the Schwartz case. Now, the Schwartz case is the famous ChatGPT case where an attorney, Mr. Schwartz, used ChatGPT to research a legal brief and filed that with the federal court. Now, the problem was it included hallucinated cases. You're probably familiar with this case. The hallucinated cases are those types of cases that, as the phrase implies, don't exist. They're made up. And if you look at one of them, this one, Varghese versus China Southern Airlines, looks like a proper citation, looks like a real case, but it doesn't walk like one. It is not a real case. You try to look it up on FindLaw or Westlaw or Lexis, and it just plain doesn't exist. So that was a problem. But what was more of a problem is that Mr. Schwartz doubled down. When it was pointed out by opposing counsel and came to the court's attention that it wasn't real, Schwartz denied that it was fake. And I think that actually here was the crux of the problem. It was early on actually in the release of ChatGPT, and likely if Peter LaDuca and Stephen Schwartz had fallen on their sword immediately and said, we use this new thing called ChatGPT, and this happened, we're so sorry, it's embarrassing, let's move on, the court probably would have, but that's not what happened. As Judge Kevin Castle pointed out, they continued to stand by the fake opinions after judicial orders called their existence into question. So candor, honesty, trumps negligence in some cases. It's best just to be honest and come forward with that and deal with it. The court, to its credit, pointed out that in researching and drafting court submissions, good lawyers, appropriately rely on assistance. Junior lawyers, law students, contract lawyers, etc. So this is, something we do, including technological advances. They're commonplace. This is the court, a quote from the court. And there's nothing inherently improper about using a reliable artificial intelligence tool for assistance. So that wasn't the problem in the court size. The problem was not coming clean. But existing rules impose a gatekeeping role on attorneys to ensure the accuracy of the filings, of course. And so the legacy of Schwartz, and there's been many, many other cases, even recent ones, where you think attorneys should know better at this point, briefs still get filed with hallucinated cases. And just recently, one attorney got fined, I think it was $15,000. Schwartz, by the way, got fined $5,000. You might query whether or not the fine is going up because it's just believable at this point that people are still doing it. Is Rule 11 enough to put a stop to this? Rule 11, which we'll look a little more in depth on, just is where an attorney says that whatever he or she files with the court, the attorney stands behind as being truthful and researched and verified. Is that good enough? Or do courts need to require some kind of AI disclosure certification, an actual certificate signed by an attorney saying, hey, I used AI for this? And the question mark behind that is that there's all kinds of AI, not just generative AI. And so old-fashioned AI, like grammar check, spell check, that's been used for years. And do you need to sign a certification for that stuff now that we never had to before? Some courts required that you certify that you did not use AI at all. As a backlash to the Schwartz case, some courts went that far, that you had to aver that you did not use AI at all. Or do you require that the lawyer receive AI education? And I know that in some of the cases where attorneys were cited for filing a brief with hallucinated cases, some of them were required to get AI education, almost like, you get a DUI and you have to go to driver's ed and rehab. Like it just was all over the place in terms of the court's different reactions to it. And so there, in the reading, you'll see that there's, local rules from different judges that take different positions. I think for the most part, courts have arrived at a place where the rules that we currently have in place, like Rule 11, are enough. And so this is it. This is what it says, that when you represent something to the court, you're certifying that it's not being presented for any improper purpose, like that you're using the system to harass people or to cause unnecessary delay. When you file something, you're saying, I'm not harassing somebody, I'm not doing this for any improper reason. Second, that the claims, defenses, and legal contentions are warranted by existing law. So they are not frivolous. They have some substance to them. Third, that the factual contentions that you're making have some kind of evidentiary support, or that you have a good faith belief that they will upon discovery. And then finally, that any denials that you have of facts are warranted on the evidence as well. So all of these things you're saying when you sign a pleading that you file in federal court with Rule 11, but states have, analogous rules, you're putting yourself on the line by standing by your work product. And so should this be enough? Probably. It doesn't matter if it's generative AI that's assisted you or if it's a colleague that's assisted you, you still need to stand behind your work. And so rules of candor and truthfulness play into this too, 3.3 and 4.1, that we have a duty to tribunals to be an officer of the court and be straight with them, but also to others, even to opposing counsel. 4.1 requires us to be honest in those transactions. Now, we don't have to share our clients' confidences, obviously, but we can't mislead them. Technology competence. So as far back as 2012, Rule 1.1, which requires competence, had a comment added that to maintain the requisite knowledge and skill, a lawyer should keep abreast of changes in the law and its practice, including that has to do with legal technology. So implied here, and not only implied, expressly stated in comment 8, was this duty to be up to date on relevant technology. And why? Because it could affect the strength of your case. If you don't understand that evidence might be, irrelevant, it might be misrepresented because of technology, that's a problem. So that's one of the reasons why, stated at the time, you needed to keep up to current technology. Now, this was, emphasized just a year ago, July 2024, by the ABA Formal Opinion 512 that dealt specifically with generative AI. So after all these cases, the ABA came down on elaborating that competence also involves understanding an AI tool's capabilities and limitations. What can it do? What can't it do? Understanding those two things is extremely important. And it doesn't mean that you have to become some AI genius. It just means that you have to be familiar enough with the tools to know their limitations and their capabilities. For example, a limitation being that it could come up with hallucinated cases. Confidentiality and communications. So this comes to bear when there's a lot of questions about security, privacy, and confidentiality in using AI tools. So 1.6 says that a lawyer shall make reasonable efforts to prevent the inadvertent and unauthorized disclosure of client information. right? And so reasonable efforts is one thing I want to emphasize, because it doesn't say perfect efforts, that the efforts that you make are impregnable, that it is impossible for someone to gain access to those confidences. Now, that's something we never want to happen. As attorneys, it's one of our paramount concerns, confidentiality of communications with our client. I get that. But that we take reasonable efforts is what we do when we do things like lock the door, lock our file cabinet. And here, Formal Opinion 512 says that, when you look at generative AI, you have to think about how to take it from the real world, locking file cabinets, locking doors, and apply that in the generative AI world. So before you type confidential information into a public AI tool, there's two things you need to think about. The first one is to carefully review the privacy policy to see how the data is retained, how it's used, if it's visible to others. And secondly, to obtain client consent if there's any risk of disclosure. You don't always have to get client consent. So if you're using a research tool, you don't have to get your client's consent about every single attempt of using an AI tool like that. It's if there's any risk of disclosure. So for example, if you didn't carefully review the privacy policy, so you have no idea, well, is there a risk of disclosure? Yes, there is, because you have no clue. So you should ask the client for their consent. Or if you review the terms of the privacy policy and perhaps there is a risk of disclosure disclosed in the privacy policy, but for some reason you really need to use that tool. Maybe the risk is worth the reward. I don't know. But that would be a situation where you'd have to get the client's consent. And for good reason. This little graphic, I just throw this in here to show you that in the real world, you have a lawyer, overworked, tons of paperwork. You got a door, you got a lock on it, got a file cabinet. Hopefully there's a lock that you can lock those files up. Keep all of this important information, including taking the sticky notes down and putting them away in some other drawer that you can lock. Those are all reasonable precautions. And I think a lot of attorneys I talked to, and it in fact just came up a couple of days ago at a conference, that an attorney raised their hand and asked the question about privacy and security and was trying to hold generative AI to a much, much higher standard than the real world. And I pointed out to that attorney that in this real world scenario, the reasonable efforts we take are quite reasonable, but they're not impossible to overcome. Somebody could break into the office. They could break the lock. They could break, into the file cabinet that's locked. In the same way, you take reasonable precautions to protect the information online. You use encryption, security, you silo off the data of one user from another user. You make sure that the data is not used for training purposes, but you can't guarantee foolproof that it will be impossible to access. Somebody with enough time, effort, creativity, and cleverness and bad intent may figure out a way to crack into that information. But some of the ways to prevent it is data encryption, so that when the information is submitted from your computer to the database that exists with the vendor, when it is in transit, when it moves, it's encrypted. Just means that it is made into a code that can't be broken, can't be broken by reasonable means. If somebody had something very sophisticated, they could break it. At the same time, when the data is at rest, when it's sitting in the database, it's also encrypted. So if somebody broke in, got into the database, it would all look like a jumble of words and numbers and special characters, unless they had some key to be able to decrypt it. AI training. So that gets mentioned a lot. What is that risk? So that risk is that you have this computer that you're working on, and you put in some, or your client puts in some extremely sensitive information like, social security number, address, phone number, all of everything personal about them, passport numbers, all of that. Now, if this AI vendor is using data submitted to it to train its models and make its models better, then it's very likely that the data submitted will be used for that purpose. And if it is, it becomes part of that model, right? It's part of the training that is captured by the weights and biases that we learned about. And it is theoretically possible, although highly unlikely, that a third party over here could request something from this AI model that's newly trained with this new information and get access to some sensitive information from your client. So in a way, it's kind of like the AI model becomes a public database where client information is stored, and then some third party, if they ask the question just the right way, may be able to get access to that information. But two things. First off, AI models are not constantly learning. They run them and train them, and then they're frozen for a period of time. That's why we've talked about AI models having cutoff dates. Like, I think 4.0 is October 2024, I think. But the point is that it's trained up until a certain point, and that's when its knowledge cuts off, because it doesn't know anything after that unless it searches the web, because it was only trained up until that point. It's not constantly grabbing new information and then putting it into its system. It only gets new information trained into it when you have another round of training, like we currently had with 4.5 coming out. So it's a very rare risk that something like this would happen, but we don't want it to happen. So we want agreements that we have with these companies to ensure that they don't train on data. That's how you avoid that problem. And so if you use the consumer-facing version of ChatGPT, there's this little setting that says model improvement, and there's a little switch. The switch, you turn it on to improve the model for everyone. You turn it off to not improve the model for everyone. And I've told you this before, they phrase it to be really sneaky so that you want to feel bad that you're not improving the model for everyone. But that means that you're not helping them by training with your private information, your private client data. So you turn it off so that it does not improve the model for everyone. Don't be that generous. OpenAI's consumer data usage, so that is, the paid version of ChatGPT that you use, not the API version that vendors use. But it says here that they will not use it unless you explicitly decide to share your data with us for this purpose, right? You switch it here so that you improve it for everyone. Well, you've explicitly chosen to share it with them. You don't want to do that, right? So that's what their data usage policy is for consumers that use it through chatgpt.com. For vendors that connect through the API, through the backend, the terms of service say that they will not use it for training purposes because they know their bread and butter from business using it through the API doesn't want that done. By contrast, DeepSeek's privacy policy, to keep it current, it says here that we may access, preserve, and share the information that you provide to comply with applicable law, legal process, or government requests. Sounds innocuous. What if they get a subpoena? That's pretty, par for the course, even in the U.S., with U.S. companies. However, PRC National Intelligence Law, Article 7 says that all organizations, meaning China-based organizations, and citizens shall support, assist, and cooperate with national intelligence efforts in accordance with law. So that is a potential legal obligation of DeepSeek because their data is housed in the People's Republic of China. If the Chinese government chooses to require that information that's on their servers and ask for it, well, DeepSeek will be obligated to provide it. So you just need to factor that in. And by the way, I would point out that this is when you use their API service that's hosted by DeepSeek. It doesn't apply if you download their model, their open source model, and then you deploy it on your own local service. That's different. This obligation and their privacy policy applies to when you use their service. Client communications. So 1.4 and 1.0 talk about that you need a client's informed consent when you talk about any aspect of their representation, like using generative AI. And if you plan to share confidential data or rely on the AI's results, you may have to let them know about your usage of OpenAI, of any generative AI that you've used in creating the work product. The reason why I mention this is because the ABA, they stop short of that. They say, you know, you don't have to tell them necessarily for using it for routine tasks. But if it could materially affect your client's case, then of course you need to tell them. And this is what I use. So for my client engagement letter, I pointed out, and I also pointed out in the positive, that we're seeking to leverage the latest technology to assist you enhance our legal services. That these technologies are utilized under strict supervision with our qualified legal team. You could also include it in the retainer agreement, where you point out that artificial intelligence is employed by the law firm, or that the law firm employs artificial intelligence for drafting, research, review of legal documents, and other work product. So I think that regardless of the jurisdictional requirement in terms of the ethical rule, that it's just good business to be clear with your clients. They might actually appreciate it and look forward to some cost savings that might result from it. And so, speaking of cost savings, 1.5 talks about the reasonableness of fees. It requires legal fees to be reasonable. Now, ABA formal opinion 512 actually spoke to that, saying that you may also need to disclose to clients any cost associated with the paid AI platform that you're using, and your fees, they need to be reasonable in light of AI usage. You can't bill for the same amount of time if it takes you less time. Supervision, delegation, UPL, they all go hand in hand. So 2.1 talks about independent judgment, that a lawyer shall exercise professional, independent judgment and render candid advice. And you can't do that if you delegate to AI without thinking about it, like Schwartz did. There was a complete delegation. There wasn't any judgment that was any independent judgment. Now, the formal opinion 512 talks about that and says you need to treat these tools as you would a human assistant. And that's one of the reasons why I've been pointing out to you that you need to think of AI as a helpful assistant, because assistants can get things wrong. So you naturally are checking them to see if they have and to correct them. If your firm's paralegal or junior associate uses an AI tool to draft a brief, you must confirm that all the content is accurate and that no client confidences were improperly disclosed. So you don't delegate that responsibility or accountability as a lawyer. You just can't. And even if you do, you can't, because you're held accountable for it, both ethically, by your license, and also monetarily. So the workflow is that regardless if it's AI or a human being submits the work product to a supervising lawyer. The lawyer reviews it to make sure that it comports with the best practices and is good work product before relating it to the client. In the same way, if an AI legal research platform develops some memo, it also needs to be researched. So take it for what it is, review it, verify it, then pass it on. It's really no different. So the UPL definition by the ABA is that it's the application of legal principles and judgment with regard to the circumstances or objectives of a person that requires knowledge and skill of a person trained in the law. There's different ways to read it. One way could imply that a person is required who's trained in the law for it to be UPL or not UPL. A person needs to be involved. What if there is no person involved? What if it's a machine? Does that cross the line? What if it's a machine where the ultimate supervision and use of the AI tool is done by a licensed person? Is that UPL? Clearly it is UPL if it's an AI that's rendering opinions and advice and guidance without any attorney involved to take accountability for it or responsibility for it. But this definition of the practice of law is, I would argue, unconstitutionally vague. It's not clear what the practice of law is exactly. And if you try to enumerate various things that lawyers do, well, there's other people that do a lot of those things too, like fill out forms or provide advice. And the definition of what is the difference between legal advice and legal information is also very ambiguous. So, although this definition is unclear, what is clear is that lawyers never give up their obligation to review, supervise, and verify the work product that they relate to their clients. Last, let's talk about minimizing bias in its sources. It's a very interesting topic, because AI uses data, it trains on data. We've talked about that compute plus data equals intelligence, right? And that the more data and compute you have, the more intelligent an AI model will become. And that there's a scaling law, or seems to be, for that over time. But what if the data is bad? Garbage in, garbage out, right? Well, it could be more subtle. It could be that maybe the data on its face looks to be correct, but that it reflects bias over time. And so one example of that is predictive policing tools. It seems like it works. Well, it seems like there's more crime in this area than other areas, but it could be that the focus historically on one neighborhood may be biased racially. It could be biased socioeconomically. It could be biased, and that's why that there's an inordinate amount of focus on a particular neighborhood, which then again results in more arrests and more prosecutions. But that it's kind of a self-fulfilling prophecy. So we can't always take the data at face value. We have to look behind it. And so some sources of bias in AI: training data bias, like I just talked about, where we'll get into a little more detail of each of these, but that's where the data itself is the problem. Algorithmic bias is one step beyond that. That's where the actual code, the actual formula that is determining, analyzing the relationships between the data and then how to make sense of it. There's some bias in that functionality. And then cognitive bias is the human element. When we all look at this, is our human judgment either implicitly or explicitly inserting bias into the determination? So training data bias is where the data sampling is of a over or underrepresented group. And it could be there's data labeling errors. Maybe the data is just labeled wrong. And because of that error, you come up with a biased result. Now, this book, Coded Bias, I highly recommend it. It's one where Joy, who she was, I believe, a PhD candidate at MIT, was conducting a facial recognition experiment. She was creating an application to recognize faces. And through that experimentation, she discovered that her face, she's an African American lady, her face was much, much more difficult for the camera, for the AI to recognize than other people. And it really caused her to question why that's the case. And it's the case because a lot of the data, a lot of the images of faces that were used to train the system were of, stereotypically white faces. And because of that, the systems were trained this is what they were trained on. This is what their normal was. And to recognize her face was more difficult for the systems. And so these are the kinds of things we need to think about. Well, if a system isn't recognizing diverse faces, just different types of faces, well, then we need to train it with different types of faces, naturally. It's just a blind spot that comes up. And that's just one extreme example. But there's many more subtle ways that it could come up and that we need to be aware of. Algorithmic bias is when there's flawed training data that results in biased algorithms. So it's even like 2 times removed, where the data actually results in an algorithm that's made from the data that fits the data, but fits data that's biased so that the algorithm itself becomes biased. Or there's programming errors that are made inadvertently in the code that cause bias. And it could be the way that vocabulary is used as kind of a short form of gauging whether or not, let's say, someone qualifies for a loan. That could result in a biased decision, or their income. So those are some examples of algorithmic bias. Then cognitive bias is when our all too human bias bleeds into what kind of data is selected, or how you weigh the data when you consider it. And that you even overlook other data which might be useful to include in what you train a model on. And some of this, it could be overlooked sources of bias itself. It could be that the bias is implicit, so you're not even aware of it. And so it does require a very careful, thoughtful review of the data and how we're selecting it to make sure that we result in the most fair and equitable system, especially if it's within the legal context, right? Because these decisions carry a lot of weight, and they're the kinds of decisions that people live with for a very long time. So we need to get it right. And so this is that book, Unmasking AI, where Dr. Joy said that the rising frontier for civil rights will require algorithmic justice. AI should be for the people and by the people, not just the privileged few. And it's interesting because the algorithms, although they are latent and not obvious, they do carry with them a certain type of justice that we need to be sensitive to, and going forward know that we have to be involved in making that work for all of us. So just to recap, we talked about the duty of competence and tech competence, how that's extremely important now, especially with generative AI, and the ABA's Formal Opinion 512 breaks that down for us. Confidentiality in communications, and how we need to take reasonable efforts to ensure that. And that in doing so, we need to look at privacy policies and terms of use for AI models and vendors to make sure that we're doing right by our clients. And remember that if we don't do that, we need to get their consent to everything. So we might as well make sure that we understand what we're working with, because that also ties into tech competence, knowing the limitations and the abilities of AI tools. And under supervision, delegation, and UPL, we can't just let go of the wheel. We have to stay involved, supervise work product, even if it's created by AI, especially if it's created by AI, and know that ultimately we're accountable and responsible for what we file with the court, what we hand over to our clients, and just to be aware of that, as we always should be. And finally, that minimizing bias in its sources is extremely important to ensuring justice for all. So thank you very much for staying for ethical and regulatory implications of AI in law, and I'll see you next time.